All right, well, it is 6:30, so we are going to go ahead and get started. We may have a few folks joining us, but I'd like to welcome everybody to this evening's program, uh, Power of Attorney for Finances and Healthcare. We're happy to be joined this evening by Evie Curtis, who will be presenting the program for us. I did want to go over a couple of housekeeping items before we get started. We are recording this evening's program and it will be made available for folks to rewatch if they need to or want to after the program. Once the recording is available, I will send out a link to the program recording for everybody. So keep an eye on your email for that. I'm also going to put a link to the survey for tonight's program into the chat. And we hope you'll take a few moments at the end of the program to let us know how we did. That also helps us to know what types of programs people are interested in. So we are going to ask that folks remain muted during the program so that we can get a good recording. If you've got questions, you can type them in chat. We will save time at the end to go over questions with everybody. And I did also want to mention a couple of upcoming programs that we have coming up. The first one that I wanted to mention is a program called Alzheimer's 101. We're going to be joined by our friends with North Kansas City Hospital, and they are going to be talking about early warning signs and how to get a diagnosis and the benefits of an early diagnosis for individuals and their family members. That is on April 23rd at 6:30 on Zoom. And then we have Eating Healthy on a Budget. This one is a hybrid program. So it is both in person at our South Independence branch as well as on Zoom. We'll be joined by the folks at University of Missouri Extension, and they'll be talking about tips for planning, purchasing, and preparing healthy meals on a budget. That one is at 6 o'clock on April 24th. And then on May 7th at 7 p.m. on Zoom, our Reader Services librarian, Angie Strathman, will be sharing recently released titles and things that are newer on the library shelves, but not the ones that have all the huge hold lists. So she does that quarterly. This is our spring one, always a good time. And then on May 14th at 7 p.m. on Zoom, we have Historic Change, Anna May Wong. We're going to be joined by a film historian, Annette Bohanec, who will be talking about the first Asian American actress who became an internationally known and depicted on U.S. currency. So she'll be talking about the life and career of this trailblazer. So we hope you'll take some time to visit our events calendar and join us for some other programs. With that, I am going to turn it over to Evie and let her get started with this evening's program.
Thank you so much, Beth. This is actually one of my favorite topics to talk about because I think it truly is a subject that there's a lot of misunderstanding around. And that's why I titled it the Did You Know This and Wish I Knew That discussion. Powers of attorney are only part of your estate plan. There are 5 basic documents. We're only going over 2 of them tonight. The other 3 being your last will and testament. When you die, what do you want to happen with those things are titled in your name and your name alone? That is a probate process. Number two, your revocable living trust. If you have a revocable living trust, not everybody does, but if you have one, that would be the second document that we're not going to talk about tonight. The third document we're not going to talk about tonight is your living will. Now, interestingly enough, a living will is actually can be combined with one of your powers of attorney, your healthcare power of attorney, and that's usually called a healthcare directive or an advance directive. We'll touch a little bit on living wills, but those are the 5 basic estate planning documents out there. Your living will, your healthcare power of attorney, your financial power of attorney, your last will and testament, and your revocable living trust. And anyone over 18 needs the first 4 of those. Not everyone needs a revocable living trust, but we all need the other 4. So we're going to jump in with a little bit of vocabulary. It's always good to introduce the words that we're going to be using. We're going to talk about the types of powers of attorney. First of all, your financial and your healthcare power of attorney can be combined into one document, or it can be separate. So we're addressing these 2 topics tonight as if they are separate documents, but they don't have to be separate documents. Your financial power of attorney controls the money. Your healthcare power of attorney controls the person. So this thing we call our body. And then you can have other specific kinds of financial powers of attorney that may do different things for different people for specific reasons. We're not going to talk about those because those are very specific. A good example would be when my children were much younger, and obviously I was much younger, and they would travel overseas with a school group. I would sign a limited power of attorney that gave the people who were traveling with my child permission to seek treatment for my child if treatment was needed. So that's a specific power of attorney. It started at when the trip began, and it ended when the trip ended. The principal under a power of attorney is the person who creates the power of attorney. Usually you. You're the person who creates it, and you're the person who's going to be signing it. The agent is the person you've elected to carry out the terms of the power of attorney, whether it's healthcare or it's financial. This is not you, because the fact that this document is in play means something has happened to you, or you have asked someone to help you with something. So the agent is who you have chosen to help you, whether it's healthcare or financial. The effective date is usually when it's signed. Doesn't have to be. It can be what we call a springing power. And a springing power means at some point in time, I want this power of attorney to start. For instance, you could have a financial power of attorney that says this does not go into play until 2 doctors have said I'm incapacitated. So that springs into effect after you find those 2 doctors. By the way, when it comes to those 2 doctors, don't do 2 doctors. You know how hard it is to get 1 doctor to sign that you're incapacitated? Imagine trying to get 2 doctors. It's near impossible. All powers of attorney terminate at your death, except, and we'll talk about that more as we get into this. I wish some of this stuff was all finite for you, but it never is when it comes to these legal documents. So let's take, all right, come here. Let's start with the financial power of attorney. There was a time when this financial power of attorney would be a 5-minute discussion when you talk about someone's estate plan. No longer. Now it is even a more powerful and important document. And the reason for that is what it controls. So here goes. The definition of a financial power of attorney: simply a legal document that grants an agent the authority to act on behalf of the principal in financial matters. So it's a legal document. It grants an agent, the person you've chosen, on behalf of the principal, that's you, in financial matters, and only in financial matters. And the document will actually lay out every single thing that your agent is allowed to do. Can they buy and sell the farm? Can they open your safe deposit box? Can they make investments? Hold on, the vacuum cleaner's going in the background. I'm going to get up and close my door. I didn't anticipate the vacuum cleaner going. Okay. It is very important that your financial power of attorney have the word durable. Usually it's in the title. It says durable power of attorney. Sometimes it's in that very first paragraph. But the word durable means if I'm incapacitated, this continues on. So durable is a very important word. Does your agent have to act? So you've been appointed to act as your sister's power of attorney. Do you have to act? And the answer to that is no. You can choose not to act. There's no protection that makes your agent step in and serve as your agent. Now, I bring this up because most people assume that if you name Evie to serve as the agent for Allison, that Evie will have to step in when Allison can't speak for herself. And Evie doesn't have to step in. Also, Evie doesn't have to report to anyone about what she is doing as agent under the financial power of attorney if she chooses to act. So I hope what this is kind of telling you is who you pick as your agent is important. What happens with families is I see the families will say, oh, well, I need to pick my oldest son, I need to pick my oldest daughter, I need to pick whatever. You don't need to pick anyone. Who's the best person for the job? Who can you count on stepping up? Who can you trust? And maybe it's not your own kids. Maybe you have to go outside your family. Something for you to think about. I think way too many people spend far too little time in making this decision on who your agent should be. It is not automatically your firstborn child. And also, if you've got 4 kids, you shouldn't be naming all 4 of your kids. I mean, when's the last time those 4 kids ever got along and all agreed on one thing? It's near impossible. Plus, you got to track them all down before you can get anything accomplished. So pick one agent, pick someone that you can trust to not only step forward, but then to also handle your affairs in a fiduciary capacity. And then also, not only do you need to pick an agent, you need to pick a successor agent. So if this agent can't serve, is unable to serve because life happens, then you need to have the next successor agent also appointed. So all very important things. Your agent is very important. Now, when your power of attorney is needed, financial power of attorney, a lot of people, the first thing they do is they walk into the bank and they say, I need to access Allison's account because I am the financial power of attorney. Well, and they think just because they have a valid power of attorney, it should automatically be honored. And tend to get a little miffed when the bank says, yeah, we don't like this document. We don't know who you are. We don't really know this person. This document is 10 years old. We don't really like this document. No, we're not going to grant you the authority to take over this account. The bottom line is financial institutions are not required to honor your financial power of attorney. Social Security won't honor your power of attorney. The VA won't honor a power of attorney. Brokerage firms, some financial institutions, they don't recognize financial powers of attorney. Good reasons for that. That is where most financial abuse and exploitation is committed, is through using these documents. So what do? What does a person do? I mean, you've taken the time to think about who these people are going to be, who you're going to appoint as your agent. You know you need this financial power of attorney. Well, what's a person to do if these organizations aren't going to accept it? Well, you have to ask them. So let's say you're receiving Social Security. Let's say you're a veteran. Let's say you have your financial assets, maybe your IRAs are at Fidelity. And let's say you bank at, I don't know, US Bank. So you're going to go into, we'll start with a bank first. You'll go into US Bank and you'll say to US Bank, here is my power of attorney. When the time comes, will you honor this document? And US Bank will say to you, no, we have a form you need to fill out, our own form. And we want you to fill it out, and you'll put in all the appropriate information. Basically, you're taking it direct out of your financial power of attorney. And then US Bank you'll sign it and it'll be notarized by US Bank and it goes into their system. Your account at Fidelity, you call Fidelity and you say, Fidelity, I have this power of attorney. I want to know if you'll honor it. And they'll say, no, you got to fill out our own form. And you'll say, well, will you please send me that form so I can fill it out? And then you're going to fill it out. So not only do you have to get these documents drafted, but then you also have to take it a step further by going to the financial institutions who will be looking at this document to see if they'll honor it. Social Security has a form that you can actually say to Social Security, when I can no longer handle my own Social Security and the payments coming in for my monthly check, I want to designate someone else to be my representative payee. And you have to fill out a form and send it in to Social Security. Same thing with the VA. You have to fill out a form and send it into the VA. So it does mean you have to take the extra steps now. Yes, back in the day, we never had these issues, but those days are over. Those days are over. We're moving on. And there's all kinds of new regulations and new kind of rules about this. Which brings us to, gosh, I have to go through so much. Should I even pay to have this document done? Why do I need to go to an attorney? There's plenty of forms out there on the internet. Well, if you think your financial institution has difficulty with the ones drafted by the law firms, they sure won't accept the ones that are drafted by the internet. And they know which ones are drafted by the internet. When you go into your bank and you have a financial power of attorney, the first thing they say is, we're going to send this to our legal department. They know which ones are drafted by the internet, and they do not like downloaded documents off the internet. When it comes to your financial power of attorney, which controls the assets that are titled in your name, it is very important that you actually seek legal counsel and get this document done correctly. A financial power of attorney ends at death. Lots of families go into the funeral home to pay for the funeral and say, I am mom's power of attorney and I have access to her checking account and I want to pay for the funeral. And the funeral home has to say to you, sorry, too late. So, and I was actually talking to a friend of mine who works with one of the local funeral homes, and she said that is the most often issue when it comes to planning for a loved one's death. And it's the last thing that you want to happen. You're already grieving. A financial power of attorney today is even more important than it was 30 years ago. Financial powers of attorney control our retirement accounts, our IRAs, our 401k plans. And very often for people today, that's our biggest asset. Every year if you're old like I am, you have to take a required minimum distribution. And you have to authorize your brokerage firm, wherever you happen to have the money, to make that required minimum distribution to you. If you're not able to do that, that's where your agent for your financial power of attorney would step in. So if this particular document is controlling potentially your biggest asset, you can see why this document can be very, very powerful. And it is very, very, very important for you to think about what happens if I'm incapacitated? Can my agent handle this? This isn't a job for the nice person in the family. This is the job for the business person in the family. And remember, you're only going to name one person. You're not going to name multiple. You are going to resist the urge to download this off the internet and think you're smarter than a financial institution is. You're going to go to an attorney to get this properly drafted. And then you're going to take the additional step and make sure that you go to your financial institutions wherever they are and make sure that they're willing to honor that document. They'll put a copy of the document on file, but it also gives you the additional responsibility when you change this document, when your life changes or perhaps your agent has passed away and husbands and wives maybe name each other. And then when you lose your husband, lose your wife, and you need to update your documents, you've also got to repeat this process and make sure your financial institutions, Social Security, all of them, make sure they have updated documents for you. And remember, this financial power of attorney does end at death. You want that word durable in there too. Okay. Take a breath. Okay. Healthcare powers of attorney. Healthcare powers of attorney, they have many names today. It could be your healthcare proxy, it could be a medical power of attorney. Some people can say, combine it with your living will and call it a call it your advance directive, your healthcare directive. So lots of different names. Bottom line is, if you are unable to speak for yourself when it comes to your body, your person, who is the person that you want to name to step in and speak for you when you're no longer able to make medical decisions? Now, this doesn't mean you're dying. You've maybe been in a car wreck and you need to have your legs set. And the emergency room physician wants to know, well, who can authorize me to set this leg? and do surgery. So, after the surgery, your leg is set, you wake up, you don't need your healthcare agent to make any more decisions, but you needed that healthcare agent at that moment in time. So this is once again, the agent doesn't have to step in. So you want to make sure the agent's willing to step in. Number two, you want to make sure the agent understands your preferences and your wishes around your health care. Now, obviously, if your leg is broken and it needs to be set, you want that done. But do you want that third round of chemo? Do you want those extra tests run that are going to cost you money out of pocket that you've always felt like were unnecessary tests? So you need to have an open and honest conversation about some of your healthcare choices and what your wishes are with this agent. Once again, you do not want to have multiple people as your agent. You want to have one person. You'll also need another backup, just in case that one person is unable to serve. But then this is the person who's able to make those difficult decisions. I've worked with so many families who mom appoints daughter as her agent, and daughter disagrees with mom's wishes at end of life. That's the wrong daughter. Pick another daughter who's willing to honor what your wishes are at end of life. If your agent accepts the role of being your agent really does have an obligation to carry out your treatment preferences if that agent knows what your treatment preferences are. So, a lot of people, they do these documents and they tuck them away in a drawer, and, they never tell the people that they've named as agent, or they might casually mention it in a conversation. It needs to be a little bit more of a serious conversation in today's world. Healthcare providers want a competent and able healthcare agent to help them make decisions for the patient, the person who is needing the care. When your agent agrees to medical test, your agent is obligating your financial resources, and your financial resources are indeed going to have to pay that bill, which is another reason why it's important for them to know what your preferences are. In most states, and certainly it includes Kansas and Missouri, because we are borderline states, your agent controls the disposition of your body. If your agent doesn't believe in cremation and you want to be cremated, you could end up with a $10,000 funeral bill versus being cremated like you wanted to be to begin with. So since the agent's controlling the disposition of your body, make sure your agent agrees with you. Another thing we had to remember. Funeral homes are certainly aware that the agent controls the disposition of the body. A lot of families are not aware that the agent controls the disposition of the body. So, healthcare powers of attorney. Very, very powerful document. It is very important that you name an agent and a successor agent who is willing to honor what your healthcare preferences are, as well as recognizing that they're spending your money when they're making the decisions they're making, and that they will carry out your decision on your funeral wishes if and when you do pass away, because we all will pass away. Most of us spend a lot of time saying what we want to happen when we pass away, where we want our money to go. And we might set up these elaborate trusts, and we might take the time to make these long lists of the family jewels and who gets what. We spend way too little time on these two documents, the financial power of attorney and the healthcare power of attorney. And these are extremely important. You know, I can remember way back when I started my career in the early 70s. I can remember when, if someone passed away suddenly, we were all, oh, that's so sad. It's just terrible that that happened. And nowadays, most of us want to just go to sleep at night and not wake up in the morning, right? So unfortunately, medical science, it has done a remarkable job. We are probably going to have a period of incapacity. And the average period of incapacity in the United States is now close to 2 weeks. Now, I know that doesn't sound like a lot of time, but if the average is close to 2 weeks, you could be one of those people that it's 4 months. I personally am going to go to bed at night and not wake up in the morning. That's what's going to happen to me. So I'm skewing the odds a little bit that you're going to end up being the person who's longer. So if we know we're going to have a period of incapacity, good heavens, let's spend a little bit more time on the durable power of attorney for financial decisions and this healthcare power of attorney. Now, when you take this healthcare power of attorney and you combine it with your living will, that's where you get your advance directive. You can download these documents off the internet. The Center for Practical Bioethics has a wonderful form document that is recognized in all 50 states. It is free. One side of the form is your living will. The other side of the form is your healthcare power of attorney. Does have to be notarized, so don't sign it without going into, perhaps your bank. Or actually today is April 16th, which is the National Healthcare Directive Day. So, there are a lot of places that actually will notarize your healthcare power of attorney for you. Anyone over 18 needs this. If you have kids that are 18 and over, make them do this. I did this to my kids one Thanksgiving. Before we had dinner, we all sat down and we talked about healthcare powers of attorney. And each one of my kids got that form. And we talked about how to fill out that form. So you can do the same thing. Now, another nice thing about the Center for Practical Bioethics, and there are other websites. I do happen to favor the Center for Practical Bioethics, but another thing about their website is they have another document you can download. It's called the Caring Conversation Workbook, and it actually walks you through just different things on how to have these conversations, what you need to gather, information you need to think about. If you've ever had to write an obituary for a loved one, and kids today, my kids today know my mom and dad as Granny and Grampy. I'm not sure they even know what their names really are. I'm Aunt Evie to my nieces and nephews. I know they probably know I'm Evie Curtis, but they may not know my real name. And they for sure don't know where I went to high school or college or graduate school. They don't know any of that stuff. So, the Caring Conversation Workbook or a notebook or a file, whatever you've got, a way of starting to gather information. You don't have to write your obituary, just gather the information together. If it's important, write it down. You don't have to publish an obituary in the paper anymore, but sometimes it's the only time that you'll see information in print on your life. So it's not a bad thing to do. Newspapers are expensive, but whether you're cremated or you're buried, funeral homes will be glad to post it on the website, and then legacy.com picks it up. So, down the road, if somebody's doing a search on family history, you know, at least your name will pop up out there. So it's definitely something for you to think about. Okay. Another breath. So we're going to go back to this topic of thinking about your agent. And I can't, because I just can't stress it enough. I see this happen all the time. People will go to their attorney and say, well, why can't you make Evie do this? Well, you can't make Evie do anything if Evie chooses not to do it. There's no law that requires me to serve as your agent when named. So, is your agent required to serve? No. So that means whoever you've appointed as your agent should be willing to serve, which means you have to share the information with them, including the document. And I've had families tell me before, they don't want their daughter to know that they've named their daughter as their financial power of attorney because they don't trust her. Well, if you don't trust her today, you can't trust her tomorrow. There you go. Name the wrong person. And once again, we talked about co-agents. You know, I got 4 kids. Should I just put all 4 of them down? I don't want one of them to have their feelings hurt their feelings. Pick the best one. Should you have a successor agent? Absolutely, because life happens and not all of us are able to serve. We might be willing, but we're not able. And so therefore having a successor is very important. If you're on this Zoom call, you know what HIPAA is. And you know how important HIPAA is. So you need that HIPAA language in your documents. And that's another reason why going to an attorney on the financial side of things, because if I'm paying your healthcare bills, for instance, as your agent under your financial power of attorney, I have to have permission to access your records. And I have to acknowledge that I have HIPAA compliant documents that allow me to do so. So, you know, HIPAA has thrown a wrench in us being able to do our jobs when we are willing to serve as agents. Another reason why you need to see an attorney. Does your agent have to do an accounting on the financial side of things? No, your agent doesn't have to do an accounting. If you think that is a fair expectation of your agent, then ask your agent. Just say, you know, every now and then, could you discuss things with my kids, or don't discuss things with my kids? Whatever your wishes are, either way. But just understand that the agent's not obligated to do an accounting of what they're spending. So if I'm your agent and I choose to, I don't know, withdraw $10,000 to run off to the Bahamas for a holiday, well, there's nobody out there policing me. So just something for you to think about. And then if you're naming someone who is as old as you are, a lot of times we do that. Husbands and wives will name each other. Once you get into a certain age, perhaps it's time to think about naming someone else to step in as your agent. Because if you're incapacitated, it just throws a wrench in things. So do think about the subject of incapacity. Could happen if you name someone same age. And then what if you have no valid document out there? What if you don't have a healthcare power of attorney? What if you don't have a financial power of attorney and you become incapacitated? And that's where the words guardianship and conservatorship come in. Conservatorship is over money. Guardianship's over the person. These are court actions. Do you want to go there? No, you don't want to go there. You didn't have to go there. You could have gotten this done. You could have gotten it done. So, yeah, if no document exists, then, you know, I work quite a bit with probate court where guardianships and conservatorships are done, and they are never pretty. And it's just a sad thing to happen. It's just a sad thing to happen. All right. I know I'm wearing you out and you're probably piling up all these questions. So what do you do with these power of attorney documents? Should we sock it away in a safe deposit box? Well, let's talk about that. So powers of attorney, whether they're healthcare or financial, come into play when something happens to us. We become incapacitated, we're unable to speak for ourselves. If you've got this document lovingly tucked away in a safe deposit box, all nice and snug and safe, and something happens to you Monday through Friday, 8 to 5, you're good to go. The problem is it doesn't happen Monday through Friday, 8 to 5. It happens at 2 a.m. on Saturday morning. Who can access your documents? So whoever your agent is, whether it's healthcare or financial powers of attorney, needs to have an original document. How many originals can you have? You can have as many originals as you want to have. So you can have multiple original documents. You are never going to use your own document. Your agent is going to use your document. So make sure your agent knows and has a copy of it. So who should have the documents? You know the answer to that now. Your agent should have the documents. And if you feel like you can't give the agent the document, you picked the wrong agent. You can certainly have an original. And for those of you who have gone to the hospital, when you check in to have, even if it's outpatient surgery, they're going to say at the desk, do you have a living will or a healthcare power of attorney? And you're going to go, by golly gee, I do. Here's my folder. It has both of these documents right here. You could go to that hospital 100 times and they still wouldn't be able to find that document. So don't think they retain those documents. Bring it with you each time you go. So who should have that document? You should have it, but your agent should have it too. How old are your documents? So if your financial power of attorney is older than 3 years, financial institutions don't like them. They want, if they're willing to even accept them, they want to see them less than 3 years old. So that means you've got to update it on a regular basis, right? Okay. If you move from Kansas to Missouri or Missouri to Kansas, happens here all the time, do you have to change your documents then? No, you don't have to change your documents then. But the next time you do update your documents, then those documents will acknowledge where your new domicile is. So some proactive steps that you can take is having conversations with your family about what your wishes are. You don't have to explain yourself to your family for the decisions that you've made. You simply can state your wishes. And I believe me, I know how difficult families can be on some of these topics. You got to stand firm. If you've made a choice on who you want as your agent, you stick with your guns. That's the way it is. And then by all means, make sure your agent understands what your preferences are. Most people will say something like, I never want to go into a nursing home. I always want to be able to stay in my own home, and you can bring in round-the-clock nursing care. Well, who can afford round-the-clock nursing care? I mean, very few people. There are a handful. It is, believe it or not, if you had round-the-clock nursing care, it is far more than it would be in a skilled nursing center. So, you know, you do have to be a little realistic in order to help your agent. Your agent should never commingle your assets and your agent's assets together. Those accounts should always be distinct, maintained separately, and funds should never be commingled. And then I know when I decided who was going to be my power of attorney under my financial decisions and for my health care, on the financial side of things, I actually took my daughter into the bank with me and made sure that I introduced her, and the bank actually went ahead and asked her to sign some forms and give them her information and put it on file. So, you know, and your bank may do the same thing. On the healthcare side of things, that's not always as easy to do. But you certainly should make sure that your doctor's office and the hospital that you frequent most often have copies of your healthcare powers of attorney and what your wishes are. And anytime you share those documents, when it doesn't say in the document the name and address and phone number or email for your agent, it's not a bad idea to provide that information to both your doctor's office and then to any of the financial institutions so that those organizations will know how to reach somebody if they need to reach someone. Banks today will just simply freeze your accounts until everything is sorted out if they have any doubts. So, I mean, that's kind of good in one aspect, but then it's also kind of bad in another aspect because your agent may not be able to do what they need to do. So, oh my goodness, that was a lot of information on what most people think are two very simple topics, and they're just not anymore. So Beth, if you're okay, I would be happy to open it up to any questions that people may have, or they could be exhausted.
We do have some questions that are showing up in the chat. The first question I want to address is about the slides, and I will email out the slides along with the link to the evaluation to everybody at the end of the program. It was sent out before the program, but if you didn't get it, I'll email it out again. And then the next question we have, are there law firms or other agencies that can be hired to be an agent?
Law firms can't be an agent. They draft the documents, and I can't imagine an attorney that would agree to be an agent. I know, yes, there are places that will serve as your agent. If you have no one, why don't you give me a call and we can explore some things? I need to know a little bit more about you before I can actually intelligently answer that for you. And on the very front slide, it has both my email address and it has my phone number. So feel free to reach out to me. And if you're willing to share a little more information, then I can do a better job of making some recommendations for you.
Okay, the next question, if I put my daughter on my bank account as an owner, she can access my money in the bank if I'm incapacitated or die, correct?
So that is absolutely correct. Your daughter is now a joint owner on that account, which means she can write a check for the full amount on that account tomorrow and just take it. Now, I know your daughter's not going to do that, but as a joint owner, when you pass away, the account is automatically hers. Yes, that is true. That works in that aspect that you're speaking of, but it is also her asset. And with anything that happens to her could impact that account for you. We don't like to see people put joint owners on accounts merely for estate planning purposes. It's just not a smart idea. And banks will encourage you to put a transfer on death or pay on death on all your accounts. And that doesn't accomplish what we've been talking about, the financial power of attorney and the healthcare power of attorney. That is not a stopgap for you getting those documents prepared for yourself. It's not accomplishing what you think it is. Yeah, you're avoiding probate, but remember, you're thinking about death. You're not thinking about incapacity or life. Oh, goodness. Okay.
Okay, and then as a follow-up question to that, I believe we've got, even if Social Security is the only thing deposited in that account.
for the daughter being a joint owner in the account?
That is my assumption, yes.
Okay, it's still, yeah, it's still, as far as the bank account is concerned, a joint account is a joint account. So you both share, it's your account and it's her account. I think what you're saying is, well, I can prove this money is just my money, that it's not my daughter's money. Well, I hear what you're saying, but your daughter has a right to, as soon as that Social Security hits the account, for her to pull it out.
Okay, and then where can you find a law firm to prepare a will along with the forms discussed today?
Oh my goodness. Well, I have lots of good law firms to recommend to you. With a wide, I mean, gosh. I don't want to actually give you any names in this program, because I don't want anybody to think that I'm trying to sell something, but I will be happy to give you my favorite three for the area that you're in. And just call me.
And I will, like you said, your email and phone number will be in the slides when they are
Mhm.
emailed out. Any other questions? Make sure I didn't miss any here in chat.
So I hope your takeaways tonight are healthcare powers of attorney and financial powers of attorney are important documents. And I'm actually going to follow through and get those documents done for myself, because I know I need them. And then when I get my documents done, I'm going to be very careful how I pick my agent. And the agent I pick, I'm going to have a conversation with that agent. And if I feel like my family's going to have a problem with any of this, I'll have a conversation with them and tell them that's the way it is, and it's not a discussable item. And that you're going to understand that planning for incapacity is equally, if not more important than planning for death. Death is easy, it's final, it's done, you can't undo it. But incapacity, people make so many mistakes, and they just don't have to be made. We just need to think more about our planning. So that's my summary for today.
We had a couple other questions pop in just now. If my daughter has trading authorization on my investment accounts, does that give her the right to pay my bills out of that account?
Probably not. Yeah, I would say probably not. I am almost 100% positive that that trading authority is limited to buys and sells. Nowhere in there does it say and pay the utility bill.
And then someone asks, are wills necessary for someone who is single and in their 30s?
They're even more necessary for someone who is single and in their 30s, because, you know, if something, it will, I mean, one day something will happen to you. And if you don't have a valid last will and testament, then the state has one for you. And we didn't talk about this tonight. It's considered dying intestate. If you don't know what the state of Missouri or the state of Kansas has for you, then I think I would maybe Google what that is and see if that's what your wishes are. It guarantees probate. You will go through probate. Someone will have to be willing to step forward to be the personal representative for you. It's just a mess. It's a mess. My very own brother did this to me. And yeah, don't do that. Get a will.
And then somebody says, I've been told that if I have everything I own with a family member's name on it, I don't need a will. True or false?
False. Scary. Call me, email me.
And someone says, thank you, very practical advice. I've completed my paperwork, but you presented events that bring the importance of having it all in order. And yes, I will be sending out the slides, and her email and phone number are on the slides. So be looking for an email from Mid-Continent after the program here. I'll send those along with the link to the survey. I'm also going to post that here in chat for those of you who like that. And thank you, Evie. As multiple people have said here, very important information, very good advice. And thank you, everybody, for coming tonight. It will probably be the end of this week or next week before we get the recording edited and available on the MCPL YouTube channel, but I will email everybody who registered the link to that once it is available. All right, well, thank you, everybody, for coming, and thank you again, Evie, and have a great evening.
Thank you, everyone.
Good night.